So now we're going to talk about reliability type exceptions. But before we do that, I want to do a quick recap. If you've been keeping track, you know that we've already covered three major groupings of exceptions to the hearsay rule in California. Our first major grouping was the prior statement exceptions. And remember, within that you had prior inconsistent statements, prior consistent statements, and prior identifications. The next grouping we discussed was party admissions, and included with that group was your party opponent admission, adoptive admission, authorized admission, statement by an agent within the scope, which is recognized under the federal rules only, and then co-conspirator statement exception. Our third group was the unavailability type exceptions, and those included former testimony, dying declarations, declarations against interest, personal or family history, and then also you had forfeiture by wrongdoing. Now we're at our fourth category, reliability type, and our fifth and final category we'll talk about next will be the documentary type exception. Now these grouping names themselves are not terms of art, and you're not going to want to headnote those on your essay. The things you're going to actually want to headnote for your grader are the specific exceptions themselves. So why did we adopt those labels in the first place? Well, we wanted to come up with an organizational scheme that would, one, make it easier for you to memorize the exceptions, and two, make it easier for you to reject or decide to talk about any one of the exceptions contained in a group. And the way that we did that is that we grouped the different hearsay exceptions according to some common thread that each of them shared within that group. So if you remember back to prior statements, the common thread that each of those three shared was that the declarant had to be available at trial subject to cross-examination. So if you had a declarant who was unavailable, you wouldn't talk or even consider discussing any of those three exceptions. For party admissions, remember, the statement had to be offered against the party who made it. So if it was being offered by the party that the statement concerns, you can dismiss and not discuss any of those five party admission exceptions there. Under unavailability type exceptions, remember the common thread that ran among those five was that the declarant had to be unavailable. If the declarant was available, you would just sort of mentally scratch out that grouping and go on to another category such as reliability type, where it doesn't matter if the declarant is available or not. And the one common thread that this next category, reliability type, shares is not so concrete and easy to nail down as it was with, say, unavailability type. The more common thread that we're looking at when we're dealing with this category is each of these exceptions bear some indicia of trustworthiness or reliability inherent within the exception themselves. And where appropriate, we'll talk about those when we get to each of these exceptions. But let's go ahead and start with our first one, which is the excited utterance exception, or in California called the spontaneous statement exception. Alright, so an excited utterance. Remember from the federal rules of evidence, this is the type of situation where someone sort of makes an outburst or exclamation in response to some startling or exciting event. The types of events you're going to be looking at, maybe a car accident, maybe someone gets hit in the head, they witness a crime, they're the victim of a crime, something that you could argue is startling or exciting, and then someone says something in response and relating to that particular event. The federal rule is that a statement is admissible if it relates to a startling or exciting event made while the declarant was still under the stress of that startling or exciting event. The only California distinctions to present for you here are in name, the fact that California doesn't call it an excited utterance, it's called a spontaneous statement, and it's the tiniest bit more narrow. Instead of it just being broadly having the statement relating to the startling or exciting event, it must narrate, describe, or explain the event. Now remember, you're only going to discuss this or any other exception if the facts raise it. So what sort of facts would raise needing to discuss a spontaneous statement? Well, there's got to be some type of an event. So you're looking, as I mentioned before, for some car crash, something that you could argue is an exciting or startling event. And then you're going to want to be looking for any sort of statement that evidences that the person who made it is still under the stress of whatever event maybe they were perceiving. You want to look for maybe the person shouted or exclaimed. Within the sentence itself, look at punctuation. If you have an exclamation mark, you can use that as evidence that someone was shouting. Let's look at our next exception, which is the present sense impression exception. Now, the difference between this and the excited utterance or spontaneous statement that we just looked at, if you remember from your federal rules of evidence, is that the event that's being perceived need not be startling or exciting. That's the main difference. When I think of a present sense impression, I think of someone who's giving a play-by-play of some sort of an event. It can be an exciting event, but note that it doesn't have to be a startling event. So it could be maybe a sports announcer giving us a play-by-play of a football game. You know, he's at the 50, he's at the 40, he's at the 30. And it could be someone who's watching a car accident just taking place. You know, they see a red car speed through a stop sign and crash or T-bone into another car, and they say, oh my gosh, that car just ran the stop sign. Well, we've got a statement that describes or explains an event, and it was made immediately thereafter perceiving the event. Now, in that fact that I just gave you, it would probably also raise the issue of excited utterance or spontaneous statement, so it's a good thing to take note of, that one set of facts can potentially raise excited utterance, spontaneous statement, present sense impression, maybe even in some of the other exceptions. And indeed, present sense impression and excited utterance tend to be raised as clusters very often on the bar exam. Now, a present sense impression is only recognized under the federal rules of evidence. The California Evidence Code does not have an exception called present sense impression. They have what's called a contemporaneous statement that we'll look at in just a second, but you'll see how much more limited it is. Now, the contemporaneous statement exception, this is the exception I was just talking about, this is found only in the California Evidence Code. The Federal Rules of Evidence doesn't have anything called the contemporaneous statement exception, but its present sense impression is probably broad enough to encompass the scenarios that the contemporaneous statement applies to. And here's what the rule is. A statement is admissible if it explains, qualifies, or makes understandable the declarant's own conduct, made only while he is engaged in the conduct. So you read this rule, you see that it has some similar language to the present sense impression exception. However, it limits the description to only the declarant's conduct, and it does not have any immediately thereafter sort of provision. It has to be made, the statement must be made while engaged in the conduct only. Let's consider this hypothetical. John ran a red light, smashed into Charlie's car. Charlie sued John for negligence. At trial, Charlie called Wes to testify that 1 week after the accident, Doc had told him, "Last week I watched with my own 2 eyes that John run a red light, crashing into Charlie." Is this admissible in the context of our hearsay rule? We just talked about several exceptions: excited utterance or spontaneous statements in California, present sense impression, and contemporaneous statement. So with those in mind, would the statement be admissible? Well, under the federal rules, let's start there. No. Even though Doc perceived the accident, his statement was not while he perceived it or even immediately thereafter. So the present sense impression exception will not apply. Remember, it has to be made while you're perceiving or immediately thereafter, and in this fact pattern, this was 1 week later. Now, presumably, there wouldn't be any stress or excitement 1 week after the accident, so Doc cannot have said the statement under such stress for it to count as an excited utterance. About California, no spontaneous statement, because it was last week, so it wasn't a statement made while perceiving an event, and there's no contemporaneous statement exception that would apply here either, because Doc, who is the declarant, remember, he's the one who made the statement out of court, he's describing someone else's conduct, John's, not his own. What about this one? Alfred tosses the keys to his car to Bruce, who gets in Alfred's car and drives off. Bruce does not return the keys or the car, claiming Alfred gave him the car as a gift. Alfred sues Bruce for conversion, and at trial seeks to offer a statement he made to Bruce as he tossed Bruce the keys, to wit, "Here, you can borrow my car for the afternoon. Is this statement admissible? Well, in the federal court, it might be admissible as a present sense impression, or maybe even as circumstantial evidence of Alfred's intent to only let Bruce have the car for a little while, so it would be excluded from the hearsay rule under that theory. But the main exception I want to talk about in relation to this fact pattern is the contemporaneous statement exception found in the California Evidence Code. This type of situation fits that exception perfectly. Alfred is qualifying or explaining why he was giving Bruce the keys, which was his conduct of tossing the keys to him. And Alfred made that statement while he was engaged in the conduct. And that's the very reason why we allow contemporaneous statements, the main reason why we allow present sense impressions, main reason why we allow excited utterances or spontaneous statements, because that there's such little time for the person who's making the statement to really process what they're saying and edit it, or otherwise lie. In other words, making the statement unreliable. The thought is that these excited utterances, these present sense impressions, these contemporaneous statements are inherently trustworthy and reliable because they're made quickly or immediately thereafter some event, and so there's little time for the person making the statement to insert their own version of events or to get it wrong, and that's the policy ground on which we admit these types of statements. Our next exception is the medical diagnosis or treatment exception. Now, what makes the medical diagnosis or treatment exception admissible, the policy grounds on which it is based, is the fact that if you make some statement to a doctor, you're most likely being truthful and honest because you're trying to get the accurate type of treatment. The thought is that when you go to the doctor and the doctor asks, what's hurting you, you're not going to say, my left arm, when really it's your right arm that's hurting you. So there's some inherent trustworthiness and reliability in these statements. The federal rule, as a quick reminder, is a statement is admissible if it was made for the purpose of medical diagnosis or treatment, and it was reasonably pertinent to diagnosis or treatment, and that can include past or present symptoms, and you can even attribute the cause of whatever pain or symptoms you're experiencing. Now, in California, this exception does exist, but in a much more narrow form. You see these additional requirements. That it's the same base requirement, still made for purpose of medical diagnosis or treatment, reasonably pertinent to diagnosis or treatment, but it only applies if the declarant is less than 12 years old and is describing an act or attempted act of child abuse or neglect. So what do you do in California if you have an adult who goes to the doctor and we have some hearsay statement made by an adult to a doctor about maybe their right arm hurts after a car collision? Are you completely out of luck? No, then you're just going to try the then existing physical condition exception that we're going to talk about in a moment. But just note that the medical diagnosis or treatment exception exists in California, but is only available to statements made by a child less than 12 describing some sort of child abuse or neglect. And this ties back to the major thematic differences we were talking about at the very beginning of this presentation. Remember, California does a lot to protect abuse victims and children in general. Conan ran a red light and smashed into Jay's Roadster. Jay was injured at the hospital 30 minutes later and after Jay had calmed down. Now, why do they give you that fact? To tell you that it's not a present sense impression because it's 30 minutes later, and that it's not an excited utterance because he's calm. So be on the lookout for words like that. But 30 minutes later, the attending physician asked Jay what was wrong. Well, the word attending physician should trigger something to deal with maybe medical diagnosis. Well, Jay says, my left leg is throbbing because it was hit by a car that ran a red light. Conan moved to strike everything after the word car. Should the court grant his motion? What do you think? Under the federal rules, yes. The first part of the statement, that his left leg is throbbing because he got hit by a car, deals with present symptoms, and the mention of what caused the symptom, being hit by a car, is also fine. But attributing fault to the cause, in other words, my left leg is throbbing because I got hit by a car that ran a red light, that ran a red light portion is not admissible under the medical treatment or diagnosis exception because running a red light is not pertinent information to medical diagnosis or treatment here. Now, under the California Evidence Code, the entire statement is inadmissible. Why? Because the declarant is not a minor less than 12 describing an act of child abuse. So in order to get that statement in California, you would have to argue that it was going to the person's then existing physical condition, i.e. their throbbing in their left leg. And that's what this one is, the then existing state of mind, emotion, or sensation. So someone can be offering up a statement that describes the declarant's then existing state of mind. You know, I am happy, I am in love, I am angry. Or they can say, you know, I am planning on doing something, or I want to do something. All that would go to state of mind or emotion, but note also you can have an existing sensation. So in that previous hypo we were talking about, where the declarant had said my left leg is throbbing, it would not come in as a statement of medical treatment or diagnosis in California, but you could argue that it evidences the declarant's then existing sensation in their left leg. In other words, it was throbbing. And it will come in the same as it does in the federal court as it does in California. And that's it for the reliability type exceptions.